Bernard Spitzer was a prominent New York City real estate developer whose son, Elliot Spitzer, was forced to resign as New York's governor because of a sex scandal. Spitzer built a real estate empire over more than 5 decades and developed major residential buildings, including several along Central Park. But in 2008, a Bronx jury awarded more than $1.3 million to a black doorman and 3 black porters who had filed a racial discrimination lawsuit against Bernard Spitzer. The 4 men, former workers at a luxury apartment house that Spitzer built and owned at 150 East 57th Street, asserted that Spitzer had them fired because of their race and replaced them by lighter-skinned workers. The jury announced its verdict after deliberating for only 4 hours. Afterwards, their trial lawyer said, the jury agreed with the plaintiffs that no one is above the law, no matter how much money that person has. Anthony Ofodile has traveled a long road to bring justice to the common people in America. He grew up in a small village in eastern Nigeria with 8 siblings and no running water. Most villagers were farmers growing crops such as yams. For water, young Anthony traveled as far as 8 miles, round trip each morning, carrying a bucket on his head, of course, for his family. He would then take the family's sheep to pasture before heading to school. Anthony's siblings took advantage of Nigeria's then free education and went to college. Anthony graduated in the top 2 of his class at the University of Nigeria, where he studied on for law school, eventually earning his law degree from New York's Columbia Law School. He specializes in civil rights and employment discrimination cases. Today, the Insider exclusive TV series meets famed New York-based employment discrimination lawyer Anthony Ofodile, principal at Ofodile & Associates, to discuss how he won this $1.3 million verdict against Bernard Spitzer in Billionaires Are Not Above the Law, including Bernard Spitzer. Anthony has earned the highest respect from citizens and lawyers alike as one of the best trial lawyers in New York City and in New York. He has seen many innocent and hardworking people become victims of the big corporation. He understands that racial and employment discrimination is one of the most serious, enduring, and divisive human rights violations in the United States. The problem is not just in New York, but nationwide, and its nature is institutionalized. And because of that, he is driven to fight for people who have been harmed by the willful or negligent actions of others. His goals, not only to get justice for his client, but to make sure all Americans have the right to a fair trial and fair judges with no agendas. This is the Insider exclusive, live from New York. It is my great pleasure to introduce Anthony Ofodile to the show. Welcome to the show, Anthony.
Thank you, Steve.
Tell our audience a little bit about your type of practice.
I do primarily civil rights and employment discrimination cases. I represent mostly the indigent, the poor, the incarcerated, who have no voice. And I try to be that voice for them. And in employment discrimination cases too, people who have lost their jobs, who have no money, who are looking for justice. I try to be that voice for them to try to get them that justice if their case so deserves it.
This is a tough practice to pursue justice on behalf of the folks that nobody seems to care about almost, right? But you do this because you're originally from Nigeria, right? You know how horrible sometimes living in these countries can be, and justice is not even there. So is that your motivation to represent these people? Is that where this comes from?
Well, I've growing up, even in Nigeria, the person who has no voice has always been the person I want to represent most. So And coming here and having the opportunity to practice, I basically continued what I had started in Nigeria and trying to work in an area I believe I'll be most useful, and also which for me will be most gratifying and satisfying.
Anthony, today we are talking about one of your other clients in your cases, and it's known as the Boyce case. It was against a well-known real estate developer, Bernard Spitzer. Tell our audience a little bit about what happened to your client and this case.
This case, the clients are represented. 4 of them were hired as maintenance and a doorman when the building was being finished. Basically, tenants were beginning to move in, construction was still going on. There was a lot of heavy cleaning to be done. And they were involved, at least 3 of them were involved from the beginning. And then when the building was finished, they needed less number of workers. But union was coming in because these buildings in New York City were represented by union. So my clients were terminated just before they could join the union, and the allegation was that they were temporary workers. Therefore, there was no need to retain them, and that they had more workers than they needed. So the reason to let them go was the need for reduction. It had nothing to do with their races or color. But our contention was that they were let go because of discrimination, because of their dark color. And, 2 of them were black, 2 were Hispanic, dark-skinned Hispanic people. And that it was Bernard Spitzer.
Spitzer's building was an upscale building, right?
It was. It was an upscale rental. It was a luxurious rental. It was built and presented as a luxurious rental building.
So the strategies what did you use here to try and prove your case? Because I understand that you had to prove that Bernard Spitzer was some way, somehow involved in some of this decision making to get rid of these people because of the color of their skin.
Well, that was our contention, and in the complaint, in trial, and before the jury. So the difficulty initially was that the corporation that Bernard Spitzer owned, that owned the building, was not sued. So Bernard Spitzer was sued as an individual. A management company was sued too, but the management company resolved with the plaintiff. So Bernard Spitzer was several levels removed technically from the decision making. So we had to show that he was personally involved in making decisions. And the way we did that was by showing that he was at the building every day, showing how he reacted to my clients and his interactions with the superintendent of the building, and how the superintendent reacted when he was coming to the building, including what he told my clients to do or where to be. So, and also we were able to show through his own admission, Bernard Spitzer's admission, that yes, the superintendent of the building, he had a right to fire him if he wanted, if he didn't do what he wanted him to do, if he didn't run the building the way he wanted to be run. So, so based on this strategy, we were able to show that even though he did not hire any of them, and they did not give them, any of them, termination notice, that he was the person who made the decision. At least I will convince the jury, and we believe the evidence supported it, and I'm convinced that that was the case then, that he was the person who made the decision to terminate them.
Now, you deposed Bernard Spitzer, didn't you?
I did.
He was an old man at the time, but what was your impression? What did you get him to concede?
He went to the building on a daily, almost on a daily basis, which my client supported when the building was being finished, that he was able to see who was working in the building. he was able to have an opinion as to whether they are doing a good work or not, and that he complained to the superintendent of the building about the work he didn't find appropriate, and he expected the superintendent to carry his instructions out. And so, based on that, I was able to show that he knew what was going on. He saw what was going on. He saw the people who were working. If he had he had the power through the superintendent to decide who was eventually kept in the building or not. And then my clients, of course, interacted with him, and some of them, there are some conversations they had with him that they were able to testify to, which I think all put together before the jury, convinced the jury that he was responsible for their termination.
Right. Now, you were up against the high and the mighty, weren't you? That had lots of expensive lawyers battling you, right?
Well, this was one of the cases I was told, at least that's what the shareholder told me was the position of the client. Even if I can pay my clients $5 million if they wanted it, I'm not going to give you anything in this case. And that was the position I was told. That was what I was told. But for me, that made my decision much, much easier. It's difficult sometimes if there's something substantial and meaningful on the table. You have to carefully advise your clients because nothing is guaranteed at trial. But when there's nothing to lose, you don't have a decision to make. So I usually like such cases where I don't have to make a decision.
In fact, I think they offered $2,000 each person, right?
Yes, they did before trial. And the primary purpose of offering that was to tell the news media, especially the New York Times, this is nuisance value. Of course, that did not cover my expenses at that time. And in any case, I usually don't respond to such offers because
it's an insult.
Yes, so I did not respond to it. Legally, ethically, I cannot call it an insult, but I there are things that are not worth responding to, so I didn't respond to that. Of course, I communicated that to my clients, and they agreed with me that we shouldn't dignify it with a response.
The jury came back with a verdict of what?
Altogether, $1,350,000 for the plaintiffs, and
that's far different from $2,000.
Yes, and because the case had been going on for a long time, if you added interest on back wages alone, it was more than $1.9 million. But it went on appeal, and it was reversed on appeal based on admission of a sentence that the appellate court said should not have been admitted.
So congratulations on that case. Okay. You gave Bernard Spitzer a run for his money, right? Mr. Micromanager, right?
Well, that is the part of the joy of doing what I do, that the big and mighty, when you have the facts and you understand the law, you can go squarely with them, and a jury of your peers or the client's peers will consider the evidence and arrive at the right decision. So that is the joy of practice.
Yeah, let's talk about some of the issues that folks need to know about if they're being discriminated against at work. What if you're not sure? What are some of the signs that you need to be aware of so that you can possibly bring a case against your employers?
Discrimination takes many forms. You know, it can be discrimination in pay, discrimination in promotion, discrimination in getting overtime, discrimination in even getting leave or the time to be out. So the best way of showing discrimination is having a comparator somebody who is of a different race or color who was treated better in the same type of circumstance. Or who was paid more, you are doing the same job, somebody was getting paid more for doing the same thing. Or in terms of raises, which was very common, especially the case we just discussed, the McCullough case, and in some of the cases I'm doing now. You have a black man or other minority who has been in the same job for 10, 15 years. On a yearly basis, he may be getting 2 or 3% raise. You have a white person doing the same job who may get 12 or 13% raise, sometimes 15% raise, doing the same job. And with the fact that many times within a short time, the white person may end up making more than the person with a long experience. So finding out that information is important, which in the private sector is very difficult. But in a place like the city of New York, because they're public employees, the pay information is public. So somebody that has such access may be able to show what is going on.
Let's give some advice to somebody who thinks they are being discriminated against, let's say in pay or position or whatever. The tendency might be to go to HR, right, and file a complaint. But what do you see happen a lot when you file a complaint in the company that you're working at?
Well, HR is supposed to be independent, but in 99% of the cases, the people you are complaining against or are complaining about are the people who hire and pay the HR people. So basically, you are complaining to a junior officer against a senior officer. So in most cases, it doesn't go well. And what happens is that corporations and employers have perfected ways to terminate somebody legitimately. So once you are targeted, you know, it's almost like what you hear in the police cases saying, stop resisting, stop resisting. It's the same phrase in employment cases, you know. So my long and short of it is that it's probably better to consult a lawyer first before you go to HR. Consult a lawyer. Yes.
Because you'll be retaliated against.
Yes, retaliation, you know, you are not supposed to do that, but it's common.
There are some protected classes in employment. What are they?
Well,
and what does that mean, protected classes?
You see, the general rule in employment cases that it's based on the common law, it's master-servant relationship, which means that the master can terminate the servant for any reason or no reason whatsoever at any time. So the protected classes depends on the state and the law. Federal law, for example, protects race, national origin, race, I spoke race or disability, sex, and to some extent sexual orientation. City law, for example, New York City law is more expansive too. So protected classes are people, for example, somebody may be black, maybe Hispanic, maybe Asian, maybe Arabic, somebody who may have a disability, somebody who may be bisexual, for example, under city law. So those are protected people. And then, of course, age is protected as well.
There's a lot of law firms in New York City. What makes your law firm different than other law firms?
We offer knowledge-based, personalized service to the client. Because employment discrimination is a major bedrock of our practice. We keep abreast with developments in the law. And my principle when I started this business is that lack of money can never be a reason I turn a client away. If I believe in the case, I'll do whatever it takes. I'll spend the money to get justice for the client. And that's primarily the reason that clients don't pay me, I pay them. Even in cases like civil rights and employment discrimination, where sometimes some lawyers who ask for $25,000, $30,000 deposit or more, or want to work on an hourly basis. Most clients can afford that.
Well, I want to thank you for the good work you do. And I want to thank you for being on the show, and congratulations on this case.
Thank you.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.